Welcome to Session 5 of the Online Human Rights Training. This will be the last session before you are certified. In this session, we are going to discuss reporting and investigations. Now that we have defined abuse, neglect, and exploitation, I want to talk about mandated reporting as a condition of employment or volunteering. Anyone who has reason to believe that an individual may have been abused, neglected, or exploited must immediately report this to their supervisor, leadership on call, or the internal human rights advocate. Reports are made through direct reporting. Direct reporting means you must call and speak to a person or leave a voicemail. It is not adequate to only write a TLOG, SCOM, or GER for the incident. You must also directly report. It is best practices to report any potential violation immediately. DSPs should always err on the side of caution when reporting. It is better to over-report than to under-report. As a condition of being an employee or contracted worker for Support Services of Virginia, remember that you are a mandated reporter. Mandated reporting means that by law you are required to report any suspected abuse, neglect, or exploitation. Failure to do so would result in termination or legal charges may be filed against you. You are also required to report peer-to-peer aggression, serious injury, including sudden illness, and death. Serious injury is defined as any event or situation that needs medical attention more than first aid. Remember, you are here to speak for people who cannot speak for themselves, to advocate for them, and to help teach the individuals you support to advocate for themselves. We're going to talk about the complaint process in just a few moments, but I want to read this regulation to you. Its heading is Assistance with Reporting. Any individual receiving services or anyone acting on their behalf who thinks that a provider has violated any of their rights under these regulations may file a complaint and may get help in filing a complaint. These regulations do not prevent anyone from pursuing any other legal resolutions. And what this regulation is talking about is that we have a right to report when we think things aren't going right with the individuals. We also need to help the individuals to understand that they have a right to say when things aren't going right as well. The individuals we support oftentimes may be afraid to say something. They may not want to say something because they don't want to lose a friendship or a relationship, or they might think that if they report something, they're not going to be able to live in the house that they're in anymore, or something might be taken away from them. So it's important that we're assisting individuals to understand that reporting things is a good thing. We want to celebrate the fact that they're speaking up for themselves, and we want to help assist them in directing them in the right direction for reporting abuse, neglect, or exploitation, or any other violation of their rights. The way that we're going to assist them is we're going to first handle the situation at the lowest levels. What I mean by that is if you can intervene and you can do something immediately to maintain the person's rights, then that's what you need to do. Not only do you need to do that, but you also need to document that that's been done. For instance, an individual says to you that a coworker of yours is being mean to them. And you go to the coworker and you say to the coworker, you know, Johnny was saying that you were being mean to him. I don't really think that you were, but can we have a conversation about it? And the coworker says, sure. So you, the coworker, and the individual sit down and you talk to the individual about why they were thinking the coworker was mean. And the coworker and the individual work it out, and the coworker apologizes and says to the individual, I really didn't mean to make you feel bad or make you think that I was being mean to you, and the situation's resolved. The individual doesn't complain about it anymore. The coworker and the individual seem to be having a great time together whenever you're on shift. There's no need to take that any further. You've handled it at the lowest levels. Now, let's say that that same situation occurs and the individual says that one of your coworkers is being mean to them, and you approach the coworker and the coworker refuses to talk to the individual about it. And you also notice that this coworker is using words that could demean, humiliate, or intimidate the individual. You protect the individual from that coworker by maybe redirecting them to take a walk, and you notify your supervisor immediately. You've now handled the situation, but you've taken it to the next level because now it's out of your hands. There is a violation of the rights, you're not able to handle it in the position that you're in, so you're reporting it to your supervisor, who's your next level. It is also appropriate at that time, if you can't handle it, depending on the nature of what's occurring, if you can't handle it at the lowest level, it's appropriate to take that to Jean as well. So either your direct supervisor or Jean Cullison, or if you're in a different division, your internal human rights advocate. What's going to happen then is there's going to be an investigation. And we're going to talk about the investigation process in just a few moments. The bottom part of the slide says these regulations do not prevent anyone from pursuing other legal resolutions. So if we believe exploitation is happening, for example, and we don't have enough evidence to prove that it actually was exploitation, just because Support Services of Virginia doesn't have a founded human rights complaint in that area, that doesn't mean that a family member couldn't take legal actions against you or whoever else was accused of that violation. So that's what that's talking about. Let's go ahead and take a look at the next slide. Here are some regulations that cover complaints. Each individual has the right to make a complaint that provider has violated any of the rights assured to them by the HRR. Have a time and fair review of the complaint. Have someone file a complaint on his behalf. Use these and other complaint procedures. Make a complaint under any other applicable law, including the DLCV. Complaints continued. The individual shall be contacted by the director within 24 hours, have access to an advocate for assistance, be protected from retaliation and harm, have the complaint reviewed, investigated, and resolved as soon as possible, receive a report with director's decision and action plan within 10 working days, be notified in writing of his right to and the process for appealing the LHRC. Complaints continued. Upon receipt of complaint, providers shall notify DBHDS ASAP no later than the next business day. Ensure director contacts the individual about the complaint within 24 hours. Initiate an impartial investigation or resolution ASAP but no later than the next business day. Take steps necessary to ensure individual is protected from retaliation or harm. Complaints continued. Assist the individual in understanding the HR complaint process, the provider's policies, and the confidentiality of involved information. Ensure communication in a manner, format, and language most easily understood by the individual. Adhere to reporting requirements. Report director's decision within 10 working days to individual, AR if applicable, and the advocate. Hopefully these regulations referring to the complaint process help to clarify why the investigation process exists the way that it does at Support Services of Virginia. In just a few moments, we're going to take a look at the investigation process. The investigation process. Before we discuss the investigation process, let's take a look at a couple of terms that need to be clarified. An individual, family member, or member of the general public or other employee of SSVA may file a complaint against you. A complaint is a situation that arises that concerns the individual, family member, coworker, or member of the general public, or are areas that the individual or family members are dissatisfied with. For example, don't feed Johnny waffles anymore. He doesn't like waffles, yet waffles are still on the individual's menu. Usually complaints come from family members or the individual. Complaints are still reported to the internal human rights advocate and documented on T-logs. Remember to directly report and document the complaint, what you or others have done to resolve the complaint, and the individual or family member's response to what you tried. Also document the name of the person or persons you directly notified. An allegation is when another staff member, the individual, a family member, or member of the general public reports something that clearly falls into abuse and neglect. Again, you intervene at the lowest levels, protect the individual, directly report immediately, and document. For complaints or allegations, immediately notify the local human rights advocate, your supervisor, or leadership on call directly. You will notice that the regulations say not to exceed 24 hours. It is best practices that we report and document within 24 hours of the incident. However, do not let that stop you from reporting. It is better to report late than to not report at all. The regulations also say that retaliation against employees who report abuse to an outside entity is forbidden, meaning SSVA cannot retaliate against you for reporting to an outside entity. Also, it is important to know that SSVA has zero tolerance for retaliation by other employees or your supervisor for reporting to an internal advocate. The advocate is trained to take precautions that will prevent others from knowing who made the report against them. Lastly, employees are required to initiate or cooperate with any investigation within 24 hours. Your internal human rights advocate. The internal human rights advocate for your division is a highly trained professional. The advocate is trained in the human rights regulations, SSVA policies, procedures, and reporting processes. The internal human rights advocate is required to conduct investigations in a fair and timely manner. The advocate is looking for a preponderance of evidence, meaning there is enough evidence to support that an allegation occurred. Internal human rights advocates make decisions about outcomes of human rights investigations. An outcome could include retraining, corrective action, or termination, depending on the nature of the allegation or complaint and their findings. The regulations state investigations must be completed within 10 business days. SSVA attempts to complete them much sooner, and best practices are to complete the investigation within 3 days. Decisions again are made based on the report and whether abuse, neglect, or exploitation occurred. Standards for this decision is preponderance of evidence. Now let's take a look at the investigation process. I'm going to use an example of possible neglect in care to explain this to you. I have used the example of an individual sitting for a long period of time in urine-soaked briefs. So let's continue to use that example to walk through the typical investigation. You arrive to shift and notice that the coworker has not assisted the individual with using the restroom because there is a strong odor coming from the person. When you assist the individual with using the restroom and changing their brief, you notice that the brief is saturated in urine and the urine is cold, making you suspicious that the individual may have not gotten assistance for quite some time. Once you have finished assisting the individual, you pull the coworker to the side and discuss the situation. The coworker states that this is their first time working in the home and they are very sorry. They did not even know the individual wore a brief. The incident never occurs again. You have handled the situation at the lowest level. You would still report this directly and document the situation on a T-log, what the response was from the coworker and the outcome. Once you have done this, an investigation or complaint may or may not occur. Let's take a look at the same situation. You arrive on shift and find that the individual is sitting in urine-soaked brief. Only this time, when you talk to the coworker, they tell you to mind your own business and that the individual is just trying to get attention. At this point, you cannot handle the situation at the lowest level, so you would report the incident immediately to your supervisor, leadership on call, or your internal human rights advocate for your division. Once the verbal report has been given, the internal human rights advocate will conduct an investigation, and this would be an allegation. What the internal human rights advocate is looking for is preponderance of evidence. Is there enough evidence to support that the allegation occurred? If the internal human rights advocate is conducting an investigation, immediate action is required to protect the individual. During the investigation, the regulations require that the person under investigation can have no further contact with the individual. For peer-to-peer aggression, action must be taken to protect the individual. So during the investigation, if you are the one being accused, you cannot work with the individual during this time. For sponsors, the individual may have to temporarily be moved out of your home. Once the investigation is complete, the internal human rights advocate will inform you of the outcome. Unfortunately, in order to keep investigations fair, the human rights advocate cannot talk to you or others about the allegation or complaint in full detail. Sometimes you have not done anything wrong, but under the law, SSVA or providers must separate you from the individual and conduct an investigation. Again, here is another regulation talking about as a provider that we have to protect the individuals from contact with the employee or with the peer that is violating their human rights. We have the right to temporarily reassign the employee or suspend the accused employee to a position that has no direct contact with the individuals receiving service. There have been times where we have reassigned an employee, and again, it's going to be case-by-case basis. Ultimately, that is going to be the decision of the president of the company or the vice president of the company as to whether we reassign the person or we suspend them. This regulation is talking about employee suspension, and as we discussed earlier, if you are suspended due to an investigation, we do not pay you for that time that you miss unless the investigation is unfounded, in which case if you do have the ability to put in for leave, then you would be able to submit your personal leave for that missed time. For sponsors, if there is an accusation in your home, the individual may be relocated during the time of the investigation so that you would have no further contact with the individual if you were the one that was accused. Appeals. If the individual affected by abuse, neglect, or exploitation or their authorized representative is not satisfied with the results of an investigation, they or the authorized representative or anyone else acting on their behalf may file a petition for an LHRC hearing. What this means is that if a family member, authorized representative, or the individual is dissatisfied with the outcome, they can file an appeal. Employees who are under investigation for allegations cannot appeal. Congratulations, you've completed the final session of SSVA's online human rights training. Now proceed back to Moodle to take your quiz and then get your certificate. Once your final quiz is received, you will be certified in human rights for 1 more year.